Welcome to all, and thank you for coming out to tonight's meeting of the Peoria Planning and Zoning Commission. I'm going to take roll call. Commissioner Nancy Golden.
Present.
Commissioner Leonard Spriker is not here tonight. Commissioner Sean Hutchinson is not here tonight. Commissioner Bill Lewis.
Present.
Commissioner Jay Outluski.
Here.
Commissioner Jeff Nelson.
Present.
Commissioner Mitch Bolnick.
Present.
And I'm Commissioner Lee Strickman. I'm going to dispense with reading the opening statement tonight. And to call to submit speaker requests, there's nobody out there to submit any speaker request forms, so the next item is the consent agenda. The consent agenda is for items that are routine in nature and consist of 2 items tonight. 1C is the disposition of absence, discussion and possible action to approve and excuse the absence of Secretary Sean Hutchinson from the Planning and Zoning Commission meeting held on February 4th, 2016. 2C is the minutes, and that's discussion and possible action to approve the minutes of the Planning and Zoning Commission meeting held on February 4th, 2016. Do any commissioners have any questions? Do I have a motion?
Madam Chair,
Yes, Commissioner Lewis.
I move for approval of the consent agenda as presented.
Thank you. Do I have a second?
I'll second that.
Thank you. Please vote. And that passes. The next agenda, we now move on to new business, and the first agenda item is 3R CU 15-0021 Speedy Pond. We have been asked for a continuance of that item, and do I have a motion to move it to the next meeting on March 17th, 2016?
Madam Chair,
Commissioner Lewis.
I make a motion that we continue item CU 15-0021 to the March 17th, 2016 meeting.
Thank you. Do I have a second? Commissioner
I
Nelson.
second the motion.
Thank you. Please vote. And that passes. Thank you. The next agenda item is 4R Z15-0015, and I'm going to try not to kill this name. Lakshmapathy? Is that close? Lakshmipathy.
Lakshmi is the goddess of wealth. It's a Hindu goddess. Pati is the husband.
Okay.
Husband of the goddess of wealth.
Oh,
Lakshmipati.
thank you. Staff, please present your report.
Thank you. Good evening, Madam Chair, members of the Commission. The case you have before you tonight, Z15-0015, is a request to rezone approximately 2.64 acres from its current designation of general agricultural to R135 single-family residential. The site is located north of the northeast corner of 99th Avenue and Joe Max Road. If you'll remember, a little while back, we had an application for Calderwood Court, which is directly adjacent to this site. As you can see, the general plan designation over this area is low-density residential with a land use of 2 to 5 dwelling units per acre with a target of 3. To the north, south, and east, you have the Pleasant Valley planned area development for single-family residential. And as I mentioned, to the west, you have Calderwood Court, which was previously approved. The current designation of the subject site is general agricultural. To the west, you have Calderwood Court, which was approved at R135, single-family residential, which is the same designation that the applicant seeks on the subject site. The justification for this request is that it provides a continuation of the R135 zoning district that we have located at the adjacent site of Calderwood Court. Additionally, it's a more contextually appropriate zoning district adjacent to the Pleasant Valley PAD, which ranges from approximately 12 to 15,000 square foot lots, whereas the minimum size of parcels within the R135 zoning district would be 35,000 square feet. The requested rezone meets the intent of the general plan, which allows zoning districts from lower intensity land use categories to be located in the next level higher land use category. So in this case, R135 zoning districts would typically be located in the estate density residential land use category. However, as I mentioned, the area is categorized as low density residential, which is one step up from estate density residential. So even though it would fit within that lower intensity category of 0 to 2 dwelling units per acre, the general plan provides a mechanism to allow it within the more intense category of 2 to 5 dwelling units per acre. Notification was provided in accordance with the zoning ordinance stipulations, mailing out notification of application and notice of hearing to property owners within 600 feet and HOAs within 1 mile. The site was also posted in accordance with the city's requirements. Staff has not received any opposition or support for the case. The neighborhood meeting was held at Sunrise Mountain Library on February 1st at 6 p.m. There were 5 residents that were present for the meeting. There was no voiced opposition or support for the application. Staff's findings are that the proposed zoning district is in conformance with the goals and objectives set forth in the City of Peoria General Plan. The general plan does allow densities between 0 to 2 dwelling units per acre in the low density residential category. As I mentioned, Chapter 14 of the general plan provides that mechanism to allow them within the more intense land use category. Additionally, the proposal provides a zoning district that allows for development compatible in scale and intensity with the adjacent area and provides for an appropriate continuation of the R135 zoning district. As a result, staff recommends approval of case Z15-0015, rezoning the property from general agricultural to single-family residential R135. And with that, I'll take any questions.
Thank you. Do any commissioners have any questions? Commissioner Golden?
I was just wondering, when you went to the public, when there was the public meeting, were there any concerns at all expressed?
No, people seemed generally pleased with the request once they were able to take a look at the plans and know really what the applicant was requesting. The postcard and letter provided them with information, but I think it's generally always helpful when they're able to see it in person.
So they're really, I mean, they were there out of curiosity, not because they were opposing anything?
That's correct.
Okay, thank you.
Do any other commissioners have any questions of staff? Okay. Would the applicant wish to speak?
No, if anybody has questions, I can explain it, otherwise, good.
Okay. Are you in agreement with staff recommendations?
Yes.
Okay. Do any commissioners have any additional questions? Okay, if not, do I have a motion? Oh, I'm sorry, you're right. I have opened the public hearing, thank you. Now, do any other commissioners have any questions? No, okay, so now I close the public hearing. I have closed the public hearing. Do I have a motion?
Madam Chair, I'd like
Commissioner
to,
Nelson.
thank you. I would move that we forward a favorable recommendation to City Council for case number Z15-0015, subject to the conditions and stipulations outlined in the staff report.
Do I have a second?
I'll second that.
Thank you. Please vote. Okay, and that has passed. Moving on to the next agenda item, that is 5R, and it is a study session, and it's TA 16-0001. And staff, please present your report.
Good evening, Madam Chair, members of the Commission. My name is Lori Deaver. I'm a senior planner with the Planning Department. The presentation before you this evening is informal in nature. It's intended to update the Commission as to why is staff undertaking the effort now to modernize the code, and no action will be taken this evening. This item is expected to be brought before you for further discussion later on in the year, so this won't be the last time you see it. So in my portion of the presentation this evening, I'm going to be talking about what is the sign code and the purpose of the sign code, and why Peoria is looking at modernizing the sign code right now. And it all has to do with a little sign in a Supreme Court case. So that's why we're here. So that one ruling actually created a new legal landscape for the way that signage is looked at, it's used, and it's regulated. And to talk about that new legal landscape, down here at the table this evening, we have the Peoria City Attorney, Steve Kemp, who will go into the specifics of that court case and subsequent opinions after that case. After Steve, Melissa Sigmund will outline staff's efforts and objectives and approach on the actual update itself, along with the projected timeframe for the project. So moving into the introduction. Take a look at the graphic, the picture on the right. It's not in Peoria. However, it illustrates why we have sign codes and why sign codes are actually throughout the nation. But what do we mean when we say the term sign code? The sign code is actually a specialized portion of the zoning ordinance. An ordinance, as we've kind of talked about and have presented, those are development standards for the look and the feel and how things operate and the way that they occur within the city. The actual purpose of the Peoria Sign Code is kind of broken into 4 categories. It's to promote public safety, support the effectiveness of signs, to promote an attractive environment, and to promote economic development. Now, in the absence of regulations, signage becomes a distraction, like you see in the picture. At the same time, too much regulation is equally detrimental. So the sign code itself balances those 2 kind of competing interests. So, our current code. The sign code for Peoria has not had a comprehensive sign update. It's not been refreshed, touched look, except in 1989. And the pictures on the side kind of give you an illustration of how things have changed since 1989. And then that was a while ago, so things have changed. We got shorter hairstyles. Our superheroes now include more superheroes and 30% more action within them. And our cell phones have gotten smarter. So things have changed, but the sign code effectively has not since that point in time. And what we recognize is there's outdated terminology within that code. And essentially, it's a one-size-fits-all approach. So what has been occurring and that the Commission has seen over time, that master plan communities, large commercial establishments have come in and have asked for specialized signage standards within their PADs. They don't typically use the standards straight out of the sign code. That inflexibility within the sign code is also problematic for areas such as the P83 and future projects that we're looking at to enhance the city and make it unique in those particular areas. So I'm going to throw out a legal term, and Steve's going to get into it a little bit more. But the regulations within the code are not content neutral. So what does that mean? From a layman's perspective, and the way that I explain it to people is a person would have to read the sign to know what sign type it is, and then be able to determine the regulations and the standards in order to enforce it. So if you have to read the sign, that's not content neutral. You're looking at what the sign actually says. In addition to those problems, it's at 48 pages. It's difficult to navigate. You're flipping back and forth between the section itself to find one portion of the standards that you need and another portion of the standards that you need. So it is challenging both to staff and both to the users and to the businesses and the residences who actually come to rely on the standards of the code. Did I mention it's 48 pages long? It is text heavy. There are multiple pages that there's nothing but text. It lacks graphics. Pictures say 1,000 words, and we've often had comments from people who've used the code that said, could you just show me what you want instead of letting me guess with what the text actually says? And we actually have 33 different types of signs that we regulate with this code. That's a lot of signs to regulate. So given the minimal updates since 1989, the Peoria sign code is already in need to be modernized. So after the Supreme Court ruling last summer, the time frame for making those changes shortened. And the method that staff has always relied on to regulate signage was found to be unconstitutional. So planners often use analogies, and the one that we most like to use is tools in the toolbox to describe how we regulate things. So to give you an example as to what effectively happened, things like safety, aesthetics, size, building materials, those would be considered tools. And those are fine. The Supreme Court said items like that, those are fine. But guys, you've got a rusty toolbox. You've got holes in it. It's outdated. The packaging that all the tools that go in no longer can be used. You need something better in which to regulate signage. So that's effectively kind of just the analogy of why we're here. So while the Supreme Court may have changed the legal landscape, we're actually looking at this as an opportunity. We already know it needs to be modernized, but now we're wanting to do so and update the code in a meaningful and useful way. And at the same time, and our primary objective is to maintain legal enforceability of the regulations. This is because of the Reed decision. So with that, I'm going to turn the presentation over to Steve Kemp.
Good evening, Madam Chairman, members of the Commission. I want to spend just a few minutes, and we're going to make this quick, to talk about the Reed case. And as you can see, this is Reed versus Town of Gilbert, and this is Gilbert, Arizona. And this arose all out of a little church meeting in a school called the Good News Presbyterian Church, and its pastor happened to be a gentleman by the name of Clyde Reed. And I'm rather familiar with this case because one of the things I do is sit on the International Municipal Lawyers Amicus Committee, and this case was looked at from the time it was in the district court all the way to the time it went to the Supreme Court repeatedly. And as fortune would have it, the Good News Presbyterian Church had these little signs up and down the roads in Gilbert. Well, Gilbert's code only allowed church signs to be out for 2 hours on Sunday. Now, home builder signs could be out longer, and other real estate signs could be out longer, but church signs could only be out for 2 hours on Sunday. And as it would occur, the Gilbert Code Enforcement must have had a lot of time because every Sunday, within an hour after the time frame was done, they were out picking up the signs and citing the church. Well, the church hired a public interest law group called the Alliance Defense Fund and sued the town of Gilbert. And somewhat surprisingly, Gilbert won in the federal district court. It went up to the Ninth Circuit U.S. Court of Appeals in San Francisco. They sent it back down to the district court. Gilbert won again. It went back up to the Ninth Circuit U.S. Court of Appeals in San Francisco. Gilbert won, but I can tell you all of us in the municipal law field were extremely concerned about this case because the argument that Mr. Reed was making is, listen, you are discriminating against my signs on basis of content. I could have an identical sign to that advertising homes for sale, and it could be up all weekend. But my sign advertising a religious service could only be up for 2 hours. That is content discrimination. Now, why that becomes important is in First Amendment law, the Supreme Court has said, listen, if you discriminate on basis of the content of the language, you have to meet 2 standards. First, you have to show that you have a compelling governmental interest in this regulation. And compelling means that there's no other way that you can achieve the government's interest except to regulate. The second standard is you have to show that your regulation is the least restrictive means to accomplish it, that it is no more stringent than it absolutely must be. Well, it was very clear the Gilbert regulation was neither a compelling state interest or the least restrictive means. This case goes up to the Supreme Court, and in the oral argument, and this was before Justice Scalia passed away, all 9 justices had lots of comments, all criticizing the Gilbert sign code, which I would tell you with this Supreme Court to get all 9 of them to agree on anything is very unusual. Then, when the opinion came down, and there was actually 4 separate opinions, but all 9 justices agreed that the Gilbert sign code was content-based and was unconstitutional as a violation of the First Amendment. And there was an opinion joined by 4 members of the majority. There was an opinion by Justice Alito, and then the 4 dissenters had 2 opinions, which I can tell you from a lawyer's standpoint, 4 Supreme Court opinions is at least 2 entirely too many. But that is the way it was. Now, I think the opinion in all of these that really made the most sense was Justice Alito's opinion, where Justice Alito basically said, listen, if you have to read the sign, that's content-based. But it isn't content-based if you are able to look at objective factors. He said, when we look at the Gilbert sign code, it's content-based because you're having to figure out and read that sign in order to determine the regulation. But when you look at Justice Alito's opinion, and that will be the next slide, he said, listen, if you're a government, if you want to regulate based on safety, based on aesthetics, based on size, based on building materials, none of that's content-based. That's all within the First Amendment. That's fine, because you don't have to look at that sign to figure this out. Now, one of the wrinkles in the Gilbert case that does pose a challenge for all of us in Arizona is about 3 years ago, our legislature decided that cities didn't know how to regulate political signs, and that it would be much better if it was regulated by the state legislature. And so the state legislature crafted a special exception for political signs that they can be in the right-of-way, and it's entirely based on content. No other sign gets this special treatment, just political signs. Now, the argument becomes then, well, why shouldn't I get the same standard if I'm a religious sign? Why shouldn't I get the same standard if I'm a home builder sign? My position would be, this is not something that the city's doing. This is something that the state legislature did, and it may well be a content-based restriction. Please go through the state and have at it, and we'd be happy to watch. But it's not a city restriction. It does pose some issues because of the way the state statute's worded, but it is something that we will work through. So, as I mentioned, Justice Alito said you could regulate as long as you look at content-neutral factors, such as the ones outlined on this slide. Now, the amazing thing about the Reed case is, I can tell you as somebody who's practiced in appellate litigation, normally a Supreme Court case is decided, and it may even change the law. but it's not generally cited in case after case after case immediately. It might be 3 or 4 years. You take a well-known case, Brown versus Board of Education, which was the case finding school desegregation unconstitutional in the 1950s. It has been cited repeatedly, but it was 2 or 3 years before an appellate court found another case where they would go back and cite that case as an established premise of law, because Supreme Court cases have that effect. They're meant to be long-term changes in the law that don't immediately alter the legal landscape. Within 6 months, the Seventh Circuit had applied the Reed analysis to the speech of panhandlers. This has also now been applied to donation bins. The messages on donation bins are First Amendment speech and constitutionally protected. It's been applied to, thankfully, to political robocalls, or maybe not so much. North Carolina statute outlawed political robocalls, and the Fourth Circuit U.S. Court of Appeals said, no, you're discriminating. You allow commercial robocalls, but you're outlawing political robocalls. That's content-based. So I guess we will all get lots more robocalls this fall. And you can thank the Fourth Circuit for that. The First Circuit applied it to a state prohibition of photographing ballots, which we actually have in the Arizona statutes as well, and said you allow other kinds of government documents to be photographed, but you don't allow a ballot to be photographed. That's content-based discrimination, and we're going to strike that down. And now, since that time, in 2 other circuits, it's been applied to charitable solicitation. So literally, in about an 8-month period, out of 11 U.S. Courts of Appeals, more than half have cited the Reed case in a major reported case on another aspect of First Amendment speech. That is virtually unheard of. And that is sort of an example of how this case is changing the legal landscape in a very, very significant way. So what are the implications and why are we here? Well, first, our sign code, like virtually, and this is nothing unique to Peoria, this is happening across the country. Again, the International Municipal Lawyers Association, we've promulgated a model sign code because jurisdictions from Portsmouth, New Hampshire to Huntington Beach, California, and everywhere in between are all having to deal with sign codes that were very, very similar. And they all regulated signs based on size, not so much on size, but content and copy and what was on the face of the sign. We can't do that. We have to be able to look at that kind of regulation in the 33 types of signs, which are identified by the content of those signs. That doesn't work. We have to be able to regulate based on objective factors, as I mentioned, things that relate to time, place, and manner, but they're objective, just not time, place, and manner, but objective items. In essence, as Lori mentioned, the easy answer here is if you have to read the sign to regulate it, it's a content-based restriction. What we have to get to is a code where literally we don't have to read anything on the face of the sign, because we're regulating those objective factors that have nothing to do with the copy and content on the sign. And so the Reed case is in effect. Obviously, if somebody challenged our sign code, we would deal with it. But the goal here is to bring us to an enforceable sign code. And with that, I'll turn it over to Melissa.
Thank you, Madam Chair, members of the Commission. So we've heard where we've been and the hairstyles we had. We've heard the legal landscape and the sea change that we've experienced now due to the Reed versus Gilbert case. And now we're going to tell you a little bit about where we're going to be going in the next year. So to start off with, we have, we've got a code that's very unwieldy. It's long, lengthy, very text-heavy, difficult for everyone to navigate. So before we dig in and have a new code, there are some questions that staff will be asking of ourselves and discussing to determine the best path forward in terms of the specific content of our new code. Questions such as what type of sign should we allow? Is it the same types we've had? Based on READ, many of the sign types may change. We'll be looking at different things, so you don't want to have a sign that talks about content in its name. We may look at changes to the size of signs. For temporary signs, as Steve mentioned, the differentiating between different types of temporary signs based on what's on the sign isn't appropriate. So we may need to look at the length of duration. So are some signs appropriate to be up for a few days, while other signs that wish to be in place for a month or so, maybe those need to have different characteristics in terms of how they're constructed or how large they are. So all of these items will be addressed by staff as we look through our current code and look to transition to something that's content neutral. So we'll be taking into account both what we're legally required to do as well as what makes sense based on current technologies and where the industry has gone as far as advertising and marketing techniques and tools. Sorry, let's see if we can, ooh, okay. Sorry about that. Turn to our regularly scheduled program here. So to go over some objectives, we will be analyzing our regulations to ensure that they're both relevant. As I said, do the standards that we have in place meet the city's needs, and in terms of both residents, businesses, everyone who would utilize the sign code. Is it clear, concise, and legally defensible? Getting rid of anything that's content-based, ensuring that it is, obviously legalese does tend to sneak into our codes to make sure that they are legally defensible, but we do want this to be a document that the public can use. If someone is coming in to get a permit, can the average member of the public understand what we're asking for in our regulations? And that's where, as Lori mentioned, many of the things we're looking at in terms of diagrams, images, illustrations, anything that can help convey what we're looking for will be part of that, that change. And in terms of the modernization, can't get over enough. The code has seen better days, and it's time to just make sure that it really is up to date. So Steve did allude to a few of the issues that we expect to face and some of the challenges that we'll be addressing. The enforceability of our sign code during the political season, if we cannot differentiate between signs types, how do we handle that? What will the landscape physically look like during those season if we have a variety of temporary signs out in the right-of-ways? That will be something that will be, we expect to put a lot of thought into. In addition, right now we have regulations that impact schools. Schools, as a separate political subdivision of the state, they're almost like another city that we're dealing with. They're certainly a large entity. They have a lot of their own regulatory authority that we can't overstep. So we'll be looking at how we interact with schools, whether we address them specifically in the sign code, or are there other manners. We have intergovernmental agreements, other types of regulatory documents or interactions that may be more appropriate. The signs in the right-of-way ties back into political signs, and as well, right now there are a number of other types of signs permitted in the right-of-way that are content-based. So we need to talk about and think about how we will, how we expect the city to look in terms of signage in our right-of-ways, and what is appropriate, and what type of regulations can be put in place to create the most appropriate setting. And the special districts, as Lori alluded to, we know we have certain areas of the city that are different from the large residential areas. We have entertainment areas, we have specialized commercial zones. We expect these to be different, and in addition to the sign code overhaul that we're undertaking and the modernization, there are additional projects that are underway. They're related, and they are certainly taking into account what we're doing with this sign code modernization, and we expect that there will be further work done to differentiate those areas and provide appropriate regulations specific to districts such as the P83 entertainment area or the auto district. Specialized regulations, the tools we get there may vary, so we're still discussing the best options and the best, as Laurie alluded to, our toolkit, we've got a number of different methods of regulation, and we will be verifying kind of which path to go as we move along with this sign code process. So location, certain signs may be located on buildings, other signs may be located freestanding, closer to the street. We can differentiate between signs of that nature based on zoning, whether we have a sign that's in a residential district or a commercial or industrial district. That's another area that we can differentiate between sign types. The duration, like I said, temporary versus permanent, or features or aspects of a sign. Is it illuminated? Does the sign, is it freestanding, and does it have the base material that is metal versus stone? These may be some of the things that we currently look at and would also intend to look at in the future with our sign code. But again, we're not going to be reading the sign. There won't be any distinguishing characteristics between if the sign is for sale or advertising a product or if it says Save the Whales. So that will not matter in our new sign code. The types of graphics that we may use to illustrate the code could be images that ensure that everyone understands what a certain sign type is, so that we're all speaking the same language. Using charts or tables so that all of the development standards, such as height, size, dimensions, can be placed in a one-stop shop, all in one place for an applicant, so that they're not digging through 48 pages of code to find the applicable regulations. There may be graphics so that we can describe what do we mean when we're talking about the height of the sign? Where is that measured from? Much easier to put in an image than it is to explain in a paragraph of words. So these are all some of the things that we'll be using to try to simplify the code and just make it user-friendly for everyone. In terms of our time frame, so you can see where we're here today. We were at commission at City Council on Tuesday. Here tonight we're before the P&Z for our first study session. We'll be having stakeholder meetings with various user groups, members of the Home Builders Association, local businesses, Multifamily Housing Association, local nonprofits and businesses, and average citizens who are interested in helping us make a better sign code. We expect to have approximately 2 meetings with our stakeholder groups, as well as additional communication to make sure that everyone knows what we're doing and it's a transparent process. We'll be bringing a draft of the code back to the commission for review, another study session to get into a little bit more detail about the actual nuts and bolts of the code, as well as City Council. All that will be occurring through spring and summer into the fall. By fall, we expect to have a final draft of the code to bring back before P&Z for recommendation, so that by the end of the year, we can have a code to City Council for final approval and adoption. So essentially, over the next 9 or 10 months, we'll be going from start to finish with the process. That time frame is important to ensure that we're trying to meet the READ decision in a timely fashion, so that we're not out of compliance for any longer than is necessary and to get a useful and appropriate code. And that's really where the end is. So you'll see this again. We expect 2 more times we'll be before you, one for the initial conversation about the specific code language, and then for the recommendation and approval before adoption by council. So with that, I'd be happy to take any questions that you may have.
Commissioner Lewis.
Thank you, Madam Chair. Just a couple comments. I don't really have any questions about it, but I'm glad to see that we're doing this. It looks like it's long overdue, 1989. That's probably a good idea for us to do it as a city. And I'm also really glad to see that you're involving the stakeholders. I would expect nothing less from you guys. The city does a great job of including our citizenry when we're making decisions that are going to impact them eventually, and look like you have a good cross-section of people that you're going to include as stakeholders in there, so that's pretty cool. I know signs can sometimes be a real emotional issue. I know when I would, in my previous life, when I would had to do some enforcement things, some of the most obscure signs issues became very emotional for people. We had neighborhoods that were always up in arms over yard sale signs that go up on, on Friday, and then they're still up on Monday, and they would call the city for enforcement of those. And then we had people that were also upset all the time about the weekend car wash, the kids who are using the Circle K to have the sign standing out there, donations for car wash. And sometimes people would call in for good reason sometimes because they're blocking traffic or it's a dangerous situation. And those were pretty easy. But sometimes those sign issues were very difficult for us to resolve at the time for the reasons that you guys were just saying tonight, because the code is so convoluted. It was difficult to read through to find out what fell into what area, what type of sign it actually was, what type of regulation. Was it a temporary? Did you need a permit? Didn't you need a permit? So I hope the end product of our new ordinance is going to be more user-friendly. I think you said in the beginning that's one of the goals that we want to do is have it user-friendly for the citizenry, so that when people call in, we have a specific answer we can give them clearly to define where their issue falls in the code, whether it's enforceable or not. And also for the inspectors, the zoning people who have to go out and take the enforcement action. So that's a pretty difficult situation when you have an obscure or an old law that's difficult to do. So, but congratulations on taking this on like you guys always do. I know we're going to end up with a really good product. So thank you very much.
Commissioner Golden?
I had two questions. One is, I know you talked about special areas like the automotive rows and things like that. Are you looking at sign regulations for the historic areas also?
Commissioner Golden, there may be additional signs or special types of signs that are appropriate. However, the great thing about opening the sign code up as a whole is that we may not need to differentiate in terms of the general signage in the area. However, we do expect to ensure that historic markers are something that is permissible. So while we're opening up the code, there may be signs that are not currently allowed today anywhere that would be both appropriate in the historic area, pedestrian-friendly signs, for instance, the shingle or the kind of traditional signs that would overhang and you could see while you're walking down the sidewalk. Something like that may be both appropriate in Old Town as well in our new commercial areas to meet everyone's needs. So.
Well, I guess I'd feel more comfortable if I knew you were going to be meeting with some of the people in the historic areas, just to validate that they don't need anything different than what everyone else has.
Commissioner Golden, we can certainly ensure that we have individuals from this area that we reach out and see if they're interested in joining the process along with the other stakeholder groups.
Okay. The other thing I want to mention is, and I say this because I'm a realtor and I see these signs all the time and they drive me absolutely bonkers, but I think it's okay because Monday morning they're going to be gone. Now it sounds like Monday morning they're not going to be gone. So I'm hoping you address that where, you go around a band and there are 32 signs for new houses going around the band. Mm-hmm. And I think, do we need 32? So I'm hoping you address that, because it means those signs, if I understand you correctly, will stay up. There won't be a time frame that they have to come down. Is that correct?
Commissioner Golden, that would all be part of the process.
I see. Okay.
Right. So we haven't made any of those decisions at this point, but certainly that's one of the areas that we expect that we'll have to have a lot of discussion on.
Oh, okay. Because I thought what you said, I thought what the attorney said was that based on content of the sign, you can't say this can stay up 2 hours, this can stay up 3 days. Did I misunderstand?
Commissioner Golden, members of the commission, yes, if the issue is solely based on content, then that's a problem. But for example, you could have temporary events where it's a single time event versus a multiple time event. And they're saying for the single-time event, it can only be up for that day. That's not a content-based restriction because we're not basing it on the content of the sign. We're basing it on it's a single-time event versus a multiple-time event. So we'll, again, be looking at those types of objective standards and how we regulate temporary signs. So some may be up a little bit longer, some may actually be up shorter, I suppose, because could be for a single event. It would be based solely on that single event.
Thank you.
Okay, I have a comment or a question. The code is going to be brought up to modernization, but the existing signs, are they going to be grandfathered in? Or we don't know that yet?
Madam Chair, in the past, we have had allowances in the code that would grandfather, quote-unquote, existing signs. The particular language or how we continue that may change. However, I don't think that there's an expectation that the signs that are out there today would immediately disappear by any means. So whether or not they have an indefinite allowance or not, that would still need to be decided. But there's not an expectation that the signs that are up there today are automatically going to be coming down, as soon as this code is passed. So.
Okay, thank you. Do any other commissioners have any questions of staff? Okay,
I'm sorry.
okay. Commissioner Nelson?
Sorry, just for clarification. So I just want to make sure I'm understanding. So in the summer of 2016, we'll actually have a document to respond to and to review and react to? Is that what I heard?
Commissioner Nelson, that is our hope and our current time frame. So.
Okay. Fantastic. Thank you.
Okay, Commissioner Bolwick?
Thank you. So when I read this court case, one thing that really bothered me was nefarious type signs, pornographic signs, somebody doing something vulgar. It almost sounds like we can't regulate that.
Commissioner Balkan, those actually get regulated, and yes, those regulations are content, but the Supreme Court has said that obscenity is not protected by the First Amendment. Okay. And so now, understand, there are some things that some folks might find vulgar and other folks aren't. For example, the United States Supreme Court has said that you may wear a jacket saying blank with a certain word ending with a K, the draft, and that's constitutionally protected under the First Amendment. And many people would find that particular word worn in a public place to be a bit vulgar. Now, on the other hand, we already regulate obscenity in terms of material that focuses on various specified parts of the anatomy or various acts of sexual conduct, and that is not protected by the First Amendment, and those regulations will continue to stay in place.
Okay. It's covered by other regulations.
Yes, and so this isn't going to be a license for bringing obscenity to the public right-of-way.
Just one other question. Did I hear you say because of a state law now we can't regulate political signs in Peoria?
Yes, the state has passed a statute. This was about 3 years ago, and in fact, there's a bill pending in the legislature to even make it broader than it currently is, where the state said that no city may enforce its codes relating to political signs, and the state said that they would preempt the field, and the state legislature would regulate political signs. So we have regulations. But, for example, we did not permit, in many cases, political signs to be in the right-of-way. Now, political signs get to be in the right-of-way, except in front of things like traffic control signs or caution signs. But other than that, or view triangles, but political signs can be in the right-of-way. That is solely a decision that the state legislature has elected to make, believing that they should have a statewide standard for this.
Thank you.
Okay. Do any other commissioners have any questions of staff? No? Okay. Next is call to the public, and nobody's here, so we won't do that. Reports from staff. Does staff have anything else to report for us?
Madam Chair, members of the commission, nothing particular, just reminded we have meetings coming up March 17th and another regular meeting on April 7th.
Okay. And Commissioner Nelson? Do you have? Oh, yeah, I'm sorry.
I just wanted to thank the city for that wonderful appreciation event that you threw for the boards and commission. That Eagles cover band was terrific. The dinner was terrific, and my wife and I had a wonderful time. And thank you very much.
And I agree with that. It was a wonderful affair that you guys put on. It was great, so thank you. Okay, seeing no further business, I call this meeting adjourned.
Well, I think we can tell
You
Chris
gonna
we're
make it home?
leaving quicker than, tell Chris.
Okay.